Okay, good evening or good morning. I'm Carmen and this is Kamryn, and we are presenting on section 10. And in this section, we will be looking at rights of parents and students, professional autonomy of teachers, academic freedom, and homeschooling. So just a little introduction. As parents, future parents, or people who care for children, we always want what is best for the children in our lives. Before our children enter school, we are the ones making all of the decisions and having the final say about every single aspect of their lives. Once our children reach school age, we are obligated as Canadian citizens to ensure they get an education. For parents, this means there are boundaries where there weren't before. There are other adults making decisions for our children where those decisions were ours alone. And there are other adults influencing and guiding our children where before this was our job alone. The goal of this presentation is to look at what rights parents have regarding their child's education and how their child is being taught and influenced within the education system. We will also look at what rights teachers have regarding their professional autonomy and academic freedom. So some of the documents that we will look at which address parents and children's rights regarding education are the Universal Declaration of Human Rights, the United Nations Convention on the Rights of the Child, and the Canadian Charter of Rights and Freedoms. So in the Universal Declaration of Human Rights, this document was proclaimed in Paris in 1948 as a common standard of achievement for all peoples of all nations and sets out the fundamental human rights to be universally protected. Article 26 addresses education specifically. And it says that everyone has the right to education. Education shall be free, at least in the elementary and fundamental stages. Elementary education shall be compulsory. Technical and professional education shall be made generally available, and higher education shall be equally accessible to all on the basis of merit. The second part says education shall be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance, and friendship among all nations and racial or religious groups, and shall further the activities of the United Nations for the maintenance of peace. And in the third part of that Article 26, it says parents have a prior right to choose the kind of education that shall be given to their children. And then next, in the UN Convention on the Rights of a Child, this is another document that teachers should familiarize themselves with. And although we don't have time to be more thorough, I felt that these sections were relevant and I wanted to highlight them. So Article 28 states that parties shall take all appropriate measures to ensure that school discipline is administered in a manner consistent with the child's human dignity and in conformity with the present convention. And then Article 29 says the development of respect for the child's parents, his or her own cultural identity, language, and values for the national values of the country in which the child is living, the country from which he or she may originate, and for civilizations different from his or her own. The preparation of the child for responsible life in a free society in the spirit of understanding, peace, tolerance, equality of sexes, and friendship among all peoples, ethnic, national, and religious groups and persons of indigenous origin. The development of respect for the natural environment. And then Article 30 states that in those states in which ethnic, religious, or linguistic minorities or persons of indigenous origin exist, a child belonging to such a minority or who is indigenous shall not be denied the right in community with other members of his or her own group to enjoy his or her own culture, to profess and practice his or her own religion, or to use his or her own language. So here I've also included some of the charter rights for reference that will be discussed in the following articles and case studies. The Canadian Charter of Rights and Freedoms sets out those rights that Canadians believe to be fundamental in upholding a free and democratic society. However, it is important to note that charter rights are not absolute and that they can be limited to protect other important rights and values when there is conflict. I'm not going to read these fully, but Section 2 is a section about fundamental freedoms. Section 7, 8, and 9 are the legal rights. And then Section 15 is equality rights in the Charter of Rights and Freedoms. And we'll be kind of referring to those later in our presentation. So the next, the article that I'm gonna talk about, addressing parental rights, the Charter, and education in Canada, the evolving story. So this article focuses primarily on rights conflicts under the Canadian Charter of Rights and Freedoms, which underscore the evolving relationship between two of these stakeholders, parents and children. The introduction of this article explains that this is a muddy area where there is often seen to be a convergence and a divergence between children's rights and interests and a parent's right to educate. Overall, it remains uncertain what restrictions may be placed on the parental right to educate when their beliefs may be seen to interfere or undermine the rights and interests of the child. The parental right to educate is protected by two provisions of the Canadian Charter of Rights and Freedoms. So in Section 2A of the Charter, the right to freedom of religion and conscience encompasses a parent's right to educate one's child. And in Section 7 of the Charter, this section protects the parent's right to control a child's religious and moral education. The interpretation provided for this protection in the article states that it is rooted in the presumption that parents should make important decisions affecting their children because they are more likely to appreciate the child's best interests and because the state is ill-equipped to make such decisions. Additionally, as parents, they have a deep personal interest in fostering growth in their own children. The article further explains that the parental right to educate is not absolute. As I stated earlier, parents will be presumed to be acting in their children's best interests unless the contrary is shown. Consequently, the state will only intervene when parental conduct falls below a socially acceptable threshold. So on that note, I wanted to take a minute to look at that wording. It states that parents will be assumed to be acting in the child's best interest unless the contrary is shown, and the state will only intervene when the parental control falls below a socially acceptable threshold. So my concern here that maybe we can talk about is in what ways can the vagueness of this statement and the open interpretation be potentially problematic for Indigenous families? And so we'll just think about that and then we'll discuss it at the end. Okay, so continuing on with the same article, parental rights and interests might not always converge with children's rights and interests. In fact, sometimes the two sets of interests conflict. So in the article, Clark examined a case study of Chamberlain versus the Surrey School District number 32, in which the Board of Trustees passed a resolution stipulating that they did not approve of the use of 3 particular books which depicted same-sex parents as recommended learning resources. The parents argued that cognitive dissonance would ensue should the books be used in the classroom. A judge ended up quashing the resolution, ruling that it violated certain provisions of the School Act of BC, and she also found that those who voted in favor of the resolution were influenced by religious considerations and were specifically opposed to homosexual behavior. The School Act prevents the board from making decisions based on religious views. In the context of public secular education, the judge held that there are limits to the amount of control that parents can exert on the selection of the curriculum. He also stated that it cannot, although parental involvement is important, it cannot come at the expense of respect for the values and practices of all members of the school community. So on the argument of cognitive dissonance, the judge explained that this argument asserts that children should not be exposed to ideas or information with which their parents disagree. And this stands in tension with the curriculum's objective of promoting an understanding of all types of families. Exposure to some cognitive dissonance is arguably necessary if children are to learn about tolerance. So continuing with that same case study, the judge explained that if we accept that children have an interest in minimal autonomy, then they should be exposed to different beliefs and attitudes so they can better understand themselves and others and ultimately make up their own minds about the types of lives they wish to live and the kinds of values they wish to embrace. So this kind of education, which results from the collision of diverse and at times contentious worldviews, is impossible without some exposure to difference and others who help us see the world from different perspectives. So I'm just going to skip that one actually. In 2009, Alberta brought in a new law which grants parents the right to withdraw their children from classes that deal explicitly with religion, sexuality, and sexual orientation, known as the Parental Rights Clause. This raised important questions about the limits of parental control in the context of public schools. So in the public domain, giving parents exclusive control over whether or not their children will be exposed to explicit discussions about religion, sexuality, and sexual orientation is fraught with difficulties. The new law appears to privilege one stakeholder and has the potential to create an educational chill by placing unjustified restrictions on a host of legitimate and important topics. So I also, so this made me wonder what this looks like in the Alberta Education Act. And here I've included some relevant sections of the Alberta Education Act, which I should mention was changed in 2019 under the UCP government from the School Act to the new and current Education Act. So what I was just talking about in the last slide, you can see here, it is in the Alberta Education Act under Notice to Parent. A board shall provide notice to a parent of a student where courses, programs of study, or instructional materials or instruction exercises include subject matter that deals primarily and explicitly with religion or human sexuality. And so the choice that's given when such topics are being discussed is to leave the classroom or a place where the instruction course or program is taking place, or to remain in the classroom or place without taking part in the instruction. And then it also goes on to say that this section does not apply to the incidental or indirect references to religion, themes or human sexuality in a course or program of study. So It's not like it doesn't refer to incidental references. It's just when it's explicitly talking about those topics. All right. Oh, we're at Kamryn's slides now. Go ahead, Kamryn.
Yes, we're going to move on to the professional autonomy of teaching. And so a lot of this information comes from the Work-Life Balance and the Canadian Teaching Profession article, and it was put out by the Canadian Teachers Federation. And so teachers' autonomy helps them to best decide what is needed and in the best interests of their students. It helps teachers decide what exactly to deliver and how to deliver with core and curricular subjects in their classes. Professional autonomy allows teachers to choose opportunities for professional development that better suit their own needs and interests instead of those inflicted by others' judgments. So that could be PDs that might be enforced by a school division or a school board or even the Minister of Education. So in February and March of 2014, the Canadian Teachers Federation had conducted an online study, and they had received over 8,000 responses from teachers across the country. And so some of the information they found was that teachers felt that they had more autonomy in relation to the pedagogical approaches in their classrooms, extracurricular activities, and student assessment and evaluation, compared to the little autonomy that they did have in regards to curriculum development and implementation, professional development, and workload. Over half of the respondents had also stated that they felt that their professional autonomy had decreased over the past 5 years, and that was either somewhat or significantly. Okay, so now we move on to kind of the topics of academic freedom and teachers' free expression. And so with teachers' autonomy, it can definitely lead us and people to wonder what can be talked about and taught in classrooms then, and also how might the law protect teachers faced with the backlash that comes from classroom content. So that might be your kids go home, they talk about what happened in school. Some parents get upset about what was talked about in class, and situations that are similar to that. And so one of the big ideas was that teachers need to know that their right to free expression does not disappear when they enter a classroom. And this can be seen within the Morin case. And so the Morin case appears to provide a level shelter to a wide variety of teachers' actions. They kind of highlighted that it could be some good actions. It could also kind of include a few not great actions. And then from the teacher's perspective, a major positive outcome of the Morin case is that the arbitrary restrictions upon teachers appear to be ripe for challenge. So it's something that we can always try and challenge. Next slide. Okay, and so we're going to get into this case study. And so this comes from the article, A Right to Speak Out, the Morin case and its implications of teachers' free expression. And so this case surrounds a grade 9 teacher named Richard Morin. And in 1988, he was removed from his classroom for showing his students a film that was critical of the Christian I cannot speak tonight, apparently, fundamentalism. So this caused outrage among the students' parents, who had made the principal aware of their disapproval, which led to Morin being taken away from his classroom. And so he wanted to complete his lesson, but he was shot down by the principal. He had went to the superintendent, but was also shut down. And then finally, the school board curriculum committee of his school division had also shut him down, saying that he couldn't complete his lesson. And so the outcome of this was that Morin was placed on a paid leave for the rest of the year and did not return for the following school year. And so the following year in 1989, Morin decided to take legal action against the school board, and his claim was organized under three sections: a breach of contract, which was eventually dismissed in court, the violation of charter rights, which was under Section 2B of Canada's Charter of Rights and Freedoms, and then defamation, which was also dismissed. And so that leads us to, it was taken to court twice. It was taken to court twice. The first time was in 1999, so a whole 10 years after he set out to with his claim against the school board. And so this was done through the PEI Supreme Court, the trial division, and it was Justice Armand Desroches. And this justice concluded that the administrator's actions did not prohibit the plaintiff from expressing himself, just merely restricted the location in which he could do so. According to the justice, it was neither the principal's intention to restrict freedom of expression, nor did his actions have the effect of restricting freedom of expression. He just commented that the purpose of the principal's decision was to create an effective learning environment for students, a task specifically included in the role description of a principal, not to restrict protected expression. So in sum, Desroches' kind of verdict was one of power to the principals. He had commented that teachers in an elementary or secondary public school have no constitutional protected right to determine, based on their own personal views, how the aims of the curriculum are to be achieved over the informed judgment of school principals and school boards. So Morin had went and appealed that, and so he went to the PI Court of Appeal, where Justice L.K. Weber reviewed his case, and in 2002, the Court of PEI, the appeal, had found that teachers have a right to free expression that extends into the classrooms. They commented if the rule/act is intended to prevent or limit your ability to do or say what you want, then this is a free expression restriction, no matter what the higher justification may be. And Weber found the whole context suggested that the purpose was to avoid controversy by prohibiting any controversial content. And thus, Justice Weber interpreted it, and the main purpose of the principal's action was to silence Morin. So that was a restriction. It was found to be a restriction on his fundamental freedom, fundamental rights. And although the court's appeal decision was immediately appealed to the Supreme Court of Canada by the school board, the Supreme Court refused to hear the case. So that case is now stands as precedent. And so one of these laws that help us as teachers is the Canadian Charter of Rights and Freedoms, Section 2B. Carmen had kind of touched on this earlier, but I'll go into a little bit more detail about it. So it's everybody has the fundamental freedoms: the freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of press and other media communication, freedom of peaceful assembly, and freedom of association. So in this freedom of expression, we're kind of looking at that point B there. And so they tend to use this thing called the Irwin-Toy test when analyzing whether free expression has been impeded on or not. And so the Irwin-Toy test says step 1 was the activity in question expression. Step 2, was the purpose or effect of the restriction to hamper freedom of expression. And then the Supreme Court also looks at, they also kind of have the Canadian Charter of Rights and Freedoms, Section 1. And so Section 1 says that the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in subject only to such reasonable limits prescribed by Law 5 as can be justified in free and democratic society. And so the Supreme Court has developed a test in order to adjudicate whether laws are justifiable under Section 1. This is called the Oakes test. So this section says so when they're looking at what you've said or what your freedom of expression is, there's a level to it, and they will say, well, either it was justifiable that, what you said is what you said, and maybe it's not justifiable. Maybe you said something that you shouldn't have said, And so the Oakes test says, is the objective of the law important enough to override the Charter of Rights and Freedoms, which is step 1. Step 2, are the means to attain the law reasonable? And from there, we look at rational connection between restriction and goal. So are the restrictions carefully tailored in order to meet the objective? Minimal impairment, is the right being restricted impinged upon as little as possible? Overall balance, are the means and the end proportional? A restrictive means must be justified by a crucial goal.
Kamryn, I think we're going to have to pause it and then restart with another video because we're going to run out of time on the Zoom meeting.
I saw that.
Yeah. All right. So I don't know how to stop it. And I'll just end the Zoom meeting now. Hang on.
Don't forget to